Hello and welcome to another video by Financial Earning. On today's video, we're going to talk about a memorandum that was provided by Mullen Automotive and Mullen Technologies attorneys in regards to the March 21st conference with GEM and their attorneys. So without further ado, let's get right into it. So before we jump into the case, it's important that we go ahead and define the parties that are going to be involved. So plaintiffs are going to be Mullen Technologies Inc. and Mullen Automotive. Defendants are going to be GEM Global Yield, as well as GEM Yield Bahamas, and Christopher F. Brown. The petitioners are going to be GEM Yield Bahamas and GEM Global Yield. Respondents are going to be Mullen Technologies Inc. and Mullen Automotive Inc. So now that you understand that, throughout this memorandum, you're going to need to pay attention when you hear the terms plaintiffs, defendants, petitioners, respondents. And they're going to go ahead and give you one more opportunity as you start to read through the intro of this. So let's go ahead. Pursuant to the court's directive made during March 21st, 2024 conference held in the above captioned matters, plaintiffs-respondents respectively submit this memorandum of law to address two specific issues. Number one, whether the above captioned actions and or plaintiffs' ongoing AAA arbitration with defendants-petitioners should be stayed. Number two, whether this court has the authority to order MAI to transfer $24 million into an escrow account in accordance with the second interim measures arbitration award issued by the arbitrator in the arbitration on or about January 24th, 2024, and that would be the interim award. As detailed below, the court should stay the confirmation of an interim award and any damages determined by the arbitrator pending this court's resolution of the securities action. In addition, there is no authority that would suggest that this court possesses the power to enter an order akin to the interim award. So that there is summarizing exactly what this memorandum is going to lay out. Mullen's attorneys went ahead and provided a lot of cases that are very relevant and support their arguments throughout this memorandum. I am not going to highlight each one of those different case studies. Just note that if you were to read through this is available on the Pacer. You would be able to find a lot of supporting documentation. So let's go ahead and continue on. So getting into the background, this is the factual background. We're going to start with Section A, the arbitration. GEM commenced its arbitration against MTI back on September 27, 2021. Several months later, GM filed an amended statement of claim which added MAI as a party to the arbitration and asserted 5 claims against both MTI and MAI, including a series of claims under the SPA and RRA, and a claim for breach of the warrant based on plaintiffs' alleged repudiation of their obligation to sell GEM shares pursuant to the warrant. On February 1st, 2022, plaintiffs filed an answer to GEM's amended statement of claim. You are not going to be able to see that answer. So throughout this document, you're going to see some redacted information. All of the redacted information has to do with specific quotes and specific items within the arbitration. So that document is sealed. That is still within the attorney-client privilege of the arbitration. So you're going to find that this memorandum deals with different items that are not part of that arbitration, and they go to show and prove to the judge that those items are not the same and cannot be treated the same. And therefore, as mentioned in the introduction, all of these specific arbitration penalties, these fees, these interim awards, those should all be rescinded or stayed. Either one of those, they mentioned stayed quite a few times, until the Securities Act concern, which is the complaint that Mullen has filed against GEM, until that comes to resolution. So let's go ahead and continue. Plaintiffs never reference sections 15A or 29B of the Exchange Act in their answer, nor did they subsequently pursue a defense or claim under those provisions. So again, that is basically lining out that they never talked about the Security Exchange Act at all during that arbitration. And we're going to find out a little bit more about that as we continue on. Number 2, or Section B, is going to be the liability award. On November 17th, 2023, the arbitrator issued the liability award. Notably, however, the arbitrator never issued an award for breach of the warrant. So again, the arbitrator never mentioned anything in terms of the warrant. It's only been about the SPA and the RRA. In describing GEM's prayer for relief, for example, the arbitrator omitted any reference to a claim for breach of contract under the warrant and instead stated that, we don't know, as I mentioned, all of that information is being redacted. But let's go ahead and continue on. However, the liability award never explicitly analyzed or adjudicated, the merits of any defenses or claims available to plaintiffs under sections 15A or 29B of the Exchange Act, nor did the arbitrator make any findings regarding GM's status as an unregistered securities dealer. Again, if you've been following this case, Mullen Automotive, they went ahead on the offense and they did file a complaint, and they're demanding a jury trial in terms of the fact that GEM, both the GEM Bahamas as well as the other GEM entity and Mr. Brown, none of those are registered security dealers. So none of those entities should be able to exercise any type of warrants. So let's go ahead and jump into section C, the interim award. On December 15th, 2023, GEM filed with the arbitrator an application for interim measures. Again, there's some redacted information. On January 24th, 2024, the arbitrator issued the interim award and ordered MAI to deposit $24,114,921 into escrow. The arbitrator derived his authority to enter the interim award from Rule R37 of the AAA rules. Rule R37 provides in relevant part that the arbitrator may take whatever interim measures he or she deems necessary, including injunctive relief and measures for the protection of conservation of property and disposition of perishable goods. So again, Mullen's attorneys are going to kind of argue that a little bit and explain why this specific amount isn't necessarily necessary. So on February 15th, 2024, GEM filed the related action and asked the court to confirm the arbitrator's interim award pursuant to the FAA and the New York Convention. On March 1st, 2024, plaintiffs filed their cross motion to vacate the interim award and to stay enforcement of the interim award pending this court's resolution of the securities action. On March 1st, 2024, the court issued an order terminating both GEM's application and plaintiff's cross motion and directing GEM to refile its application in the form of a motion for summary judgment. On March 5th, 2024, the court stayed all briefing in both of the securities action and the related action pending a conference with the court, as well as the enforcement of the interim award. So again, that was what this conference on March 21st was all about. Section 2, the court should stay confirmation of GEM's application to confirm the interim award and any damages determination by the arbitrator pending this court's resolution of the security action. So basically, Mullen's attorneys are stating that the interim award as well as any activities going on in that arbitration be put on hold until the securities action can come to an agreement. So as we know, Mullen's attorneys, again, they state that these lenders are non-registered lenders, so they are not allowed legally, according to the Security Exchange Act, able to deal in any of these types of securities. So Section A, the arbitration does not have preclusive effect on the securities action. The gravamen of defendant's request to stay the securities action in favor of the pending arbitration is that the arbitrator's passing reference in footnote 14 of the liability award to certain offenses asserted by plaintiffs should be given preclusive effect under doctrines of res judica. And for those of you who don't know res judica, you'd have to be a type of paralegal or an actual attorney to really understand that, or potentially judge. For those commoners like myself, I had to look this up. So res judica basically states that once there's judgment that's held, you cannot reopen this type of issue. So that was the concern with arbitration. If the arbitration was completed and the judgment was held, Mullen Automotive could not come back and basically try to counter that using the Security Act or the Securities Action concern. So let's go ahead and continue on. And or collateral estoppel. For the reasons discussed below, neither doctrine should be invoked as a preclusive bar to the securities action. Plaintiffs' claims in the securities action are not barred by res judica. To establish that the doctrine of res judica bars a claim in federal court based on prior determinations in arbitral proceedings, a party must show that, number one, the previous action involved in an adjudication of the merits. Number two, the previous action involved the parties or those in privity with them. And number three, the claims asserted in the subsequent action were or could have been raised in the prior action. Defendants argue that the 15A claim in the securities action was previously raised in the arbitration. In support of this assertion, defendants point to plaintiffs' two vague defenses presented in their answer to GEM's amended statement of claim. And they provide those two statements. Again, it's redacted, so we don't have that information. Those equivocal defenses, however, do not constitute the same affirmative claim asserted in the securities action. Rescission pursuant to Section 29B because the warrant was made in violation of Section 15A of the Exchange Act. Accordingly, absent any reference to Section 15A of the Exchange Act, the defenses raised in the arbitration cannot be interpreted to constitute the same claims in the securities action. So the defendants put out these two very vague statements about what Mullen's attorneys are saying. They're tying those statements saying that the warrant that was brought up is actually in violation of the Exchange Act. So the Exchange Act was not actually discussed during the argument from the defense. So I wanted to take a break from this section and kind of go into the footnotes. I thought footnotes 4 and 5 are actually pretty important. They give us a little bit more background, so let's go ahead and read those. In addition to the arguments herein, plaintiffs respectfully refer to the court to the arguments submitted in their opposition to defendants' request for stay, and add that the cases cited by the defendants in support of their stay requests are distinguishable from the case at bar. I'm going to go ahead and jump through those cases and continue down below. Section 5, plaintiffs assert two claims in the securities action. First one, which is I, a claim for rescission against GEM pursuant to Section 29B of the Exchange Act for violating Section 15A of the Exchange Act by making the warrant as unregistered dealers. And Section 2, II, a claim against Mr. Brown for violating Section 20A of the Exchange Act by acting as a control person of GEM in connection with GEM's transactions as unregistered dealers. So again, those two footnotes pretty much helped explain Mullen's defense on why they believe that it's very important that the judge considers the fact that they are working these warrants in violation of the Securities Exchange Act. All right, this next section is an actually pretty good point Mullen's attorneys are bringing up. So turning next to whether plaintiff's 15A claim could have been raised in the arbitration, courts in this district have refrained from applying res judicata to claims that arise from an agreement distinct from those previously arbitrated, particularly when the subject agreement of the litigation does not contain an arbitration provision. And they go ahead and state a case that kind of helps defend their claim or their clause here. So go ahead down here. Here, the warrant, the subject agreement of the securities action, not only lacks an arbitration provision, but it also includes an express jurisdiction and venue provision requiring that venue for any dispute arising under the warrant will lie exclusively in the state or federal courts located in New York, and the parties irrevocably waive any argument that New York is not the proper venue. The issuer and holder irrevocably consent to personal jurisdiction in the state and federal courts in the state of New York. Because the warrant does not contain an arbitration provision, it is not at all clear that the plaintiff's claim could have been included as a claim in the arbitration, and that plaintiff's claim has to do with the Securities Exchange Act. Accordingly, the arbitration proceedings do not bar plaintiffs' claims in the securities action under the doctrine of res judicata. So again, res judicata means that even if this arbitration comes to a conclusion, it cannot be brought up again. That would be what res judicata is. And what Mullen's attorneys are showing is the fact that they have the Securities Exchange Act clause, and the warrants never once mention arbitration, that you cannot, it can't be a closed book case, that this still stands on its own. And it's very important because in my opinion, and what the attorneys are stating is that if this case holds and the judge agrees that they are unregistered dealers, then the warrants are nullified, they get zeroed out. That means that the interim award amount would get zeroed out as well, because then it would have no face value in terms of warrant cost. So let's go ahead and go to the next section. Insofar as the court considers whether plaintiffs nonetheless should have raised their claims in the arbitration despite the warrant's exclusive jurisdiction provision, the Second Circuit evaluates whether the claim was sufficiently related to the claims that were asserted in the first proceeding. To demonstrate that a claim should have been previously asserted, a party must show that the prior and current claims involve the same transaction or connected series of transactions. The same evidence is needed to support both claims. So again, that's what I was saying, the fact that the arbitration is never mentioned in the warrant agreement. These two issues or concerns cannot be intertwined. And I want to go ahead and bring up some of these other footnote sections. So footnote number 6, during the conference, GEM's counsel asserted that the venue provision in the warrant is not applicable to GEM, but rather only applicable to any subsequent transferee or holder of the warrant. Section 8 of the warrant, however, defines holders to mean the persons who shall from time to time own the warrant. GEM unquestionably owns the warrant and is therefore bound by the warrant's venue provision. So there you go. They have to have this New York venue. Section 7 or footnote 7. The parties thus consented to exclusive jurisdiction in this court and irrevocably waived any objection thereto as it relates to the warrant. As such, had plaintiffs contested the validity of the warrant during the arbitration, as they do here in the securities action, they would have been in breach of the clear language in Section 11 of the warrant. To the extent that the court finds Section 11 of the warrant inconsistent with the arbitration provision in the SPA, it is well settled in New York that any ambiguity subject to confusion should be construed against the drafter, which in this case was counsel for the defendants. And they give you an example of that. So going into the first full paragraph, here plaintiffs' claims under the Exchange Act are broader in scope and unrelated to the time, space, or origin of the claims raised in the arbitration. The claims presented in the arbitration pertain to the SPA, which is Security Purchase Agreement, and the RRA, Registration Rights Agreement, and are substantively and chronologically bound to the plaintiff's alleged breaches of those arguments. Conversely, the claims arising under the Exchange Act involve GEM's conduct with unrelated third-party issuers before, during, and after the subject transaction. Going on to the section, plaintiffs' claims under the Exchange Act therefore greatly expand the facts that would have to be considered in the arbitration to determine whether plaintiffs breached the SPA and RRA, and would not so obviously have to be litigated simultaneously that one would expect both sets of claims would necessarily be brought together. While there is overlap between some facts demonstrating GEM's conduct as an unregistered securities dealer and its securities transactions with plaintiffs, the operative nucleus of facts in the arbitration arises from the SPA and RRA, not the warrant, which underlies the claims brought by plaintiffs under the Exchange Act. Even if plaintiffs, arguendo, could have raised the Exchange Act claims as counterclaims in the arbitration, permissive counterclaims in prior arbitrations conducted in New York are not precluded from being asserted in a subsequent litigation under res judicata. And neither New York law nor the AAA rules provide for compulsory counterclaims. Granted, a party is not free to remain silent in an action in which he is the defendant and then bring a second action seeking relief inconsistent with the judgment in the first action by asserting what is simply a new legal theory. So basically, I read that quote from this specific legal case because it's important to note that you can't bring up one fact and seek relief and then have an inconsistent issue with a second one. So going on here, however, plaintiffs are simply bringing a claim pertaining to GM's business conduct that extends beyond the limited transactional nucleus giving rise to arbitration. Additionally, the securities action cannot be characterized as a second suit on the basis of pre-existing claim for relief that would impair the rights or interests established in the first action. Because the claim for relief in the arbitration is for breach-related remedies under the SPA and RRA, whereas the requested relief in the securities action is the statutory remedy of rescission under Section 29B. Finally, as an unconfirmed award, the liability is not a final judgment on the merits. Whether the prior decision was a final judgment on the merits, accordingly, it remains unclear whether any rights or interests have in fact been established. All right, folks, we're about halfway through. I know some of this legal jargon can be quite a bit dry. Some of it is hard to understand. I myself do not fully understand everything, but I'm just giving you my opinion as I read it. Section 2, the plaintiff's claims and the securities action are not barred by collateral estoppel. So I'm going to go ahead and explain what collateral estoppel is and all the criteria that you have to meet in order to be considered, not barred. And then we'll talk about exactly why Mullen's attorneys state that this does not apply. So collateral estoppel is permissible if, number one, the identical issue was raised in a previous proceeding. Number two, the issue was actually litigated and decided in the previous proceeding. Number three, the party had a full and fair opportunity to litigate the issue. Number four, the resolution of the issue was necessary to support a valid and final judgment on the merits. And they give a couple case study examples. It says in addition to these four factors, the court must also assure itself that the application of collateral estoppel is fair. And then they go on a little bit further, another case study, and they quote, a party seeking to obtain summary judgment on collateral estoppel grounds based on an arbitrator's award must make a showing so strong that no fair-minded jury could fail to find that the arbitrator necessarily denied the claim for the reason they assert. The very last sentence for this section. For the reasons discussed below, defendants do not meet this burden. So now we're going to go ahead and discuss why this specific case does not meet this plaintiff, or does not meet what the plaintiff is saying, which means that this case cannot be barred by collateral estoppel. The issue of whether the warrant was made in violation of Section 15A of the Exchange Act was not raised in the arbitration. So that actually counters number one of this collateral estoppel, which says that the identical issue was raised in a previous proceeding. So they're stating right here that the warrant made in violation of the Security Exchange Act was not raised during the arbitration. With respect to the first element of collateral estoppel, an issue is raised when it is presented to the arbitrators and specified in the party's first communication to the arbitrators. They give a case study example. Collateral estoppel should not be invoked to preclude a district court action, whereas here a party asserts a Section 29B claim for rescission under Exchange Act, which itself is predicated on a violation of Section 15 of the Securities Act, and that identical claim is not presented during the arbitration proceedings. They give a case study. I'm going to go ahead and jump down to noting that the plaintiff's rescission claim may not have been necessarily been artfully pleaded. This Bulgoski, I said that wrong, court nonetheless found that the assertion of the claim was not precluded by the arbitration proceeding and left open the question thus presented whether plaintiff is entitled to rescission of his customer agreement with SRSI because SRI failed to register as a securities broker. The reason why I went ahead and read through that case is because this is what we are dealing with. GEM and their manager, their fund manager, this Mr. Brown, is not registered as a security broker. The Second Circuit's reasoning in this same case should apply with equal force to the case at bar. Here too, plaintiffs assert a claim for rescission under Section 29B of the Exchange Act, which is predicated on a violation of Section 15A of the Exchange Act and was not raised in the arbitration. While defendants contend that plaintiffs raised the same argument in the arbitration, they cannot point to a single reference to Section 15A of the Exchange Act in the arbitration. So they're claiming they talked about it, but yet they didn't mention a single time about Section 15 Exchange Act, which is the, if you want to call it, the crucible of Mullen Automotive's attorney's defense here. And again, they actually show that very vague statement, and then it says a violation of Section 15A was never raised. Going ahead a little bit further, Section 29B is not a standalone claim that can be raised without asserting a predicate violation of the Exchange Act. Rather, Section 29B is a statutory vehicle through which an aggrieved party can rescind a contract made in violation of any provision of the Exchange Act or any contract where performance involves a violation of the Exchange Act. Number two. Number one, this is if a person can avoid a contract under this section, they have to show, number one, the contract involved is a prohibited transaction. Number two, he is in contractual privity with the defendant. Number three, he is in the class of persons the act was designed to protect. Stated differently, because that was a little bit hard to understand, the issue of whether the warrant was made in violation of Section 15A of the Exchange Act is separate and distinct from, it's redacted, accordingly, defendants cannot demonstrate that the identical issue was raised in the previous proceeding. So there's a lot of discussion there, a lot of these different case studies, a lot of this backing is just to help strengthen the argument here. So going to Section II, the issue of whether the warrant was made in violation of Section 15A of the Exchange Act was not actually litigated and decided in the arbitration. So again, this is the number two for being part of this estoppel. Even if the court were to determine that the identical issue of whether the warrant was made in violation of Section 15A of the Exchange Act was actually raised in the arbitration, it was not. Defendants would still need to demonstrate that it was actually litigated and decided. Courts find that issues were actually litigated and decided in a previous arbitration where the arbitrator properly considered and resolved those issues. And they give a case study. Here, the arbitrator's commentary in footnote 14 of the liability award cannot be reasonably interpreted as a final decision on the merits of plaintiff's claims under the Exchange Act as an initial matter. And they go ahead and probably list the footnote 14. It's redacted. Going on, if nothing else, this statement establishes that the issue of whether the warrant was made in violation of Section 15A of the Exchange Act, even if the court were to consider it as encompassing the blank, was certainly not litigated in the arbitration. So whatever that statement was saying, again, Mullen's defense is saying that it was not litigated in the arbitration. Going a little bit deeper, just to kind of drive home Section 2. Furthermore, the arbitrator's statement, that blank, don't know what it says, is not the same as actually deciding on the merits whether the warrant was made in violation of Section 15A because GEM is an unregistered securities dealer. Such a finding would have required the arbitrator to actually consider whether GEM is a securities dealer within the meaning of the Securities Exchange Act, whether GEM is registered as a dealer with the SEC or any other regulatory body, and whether the warrant was thus made in violation of Section 15A. By conducting a thorough analysis of the relevant statutes, interpreting the controlling case law, and applying the facts before him to actually decide the issue, the arbitrator actually decided issues in the final award by thoroughly considering and determining the elements of the claim at issue in the second litigation. So they gave a case study that said basically in order to come up with a final award, you have to consider all the elements, which in this case would include the Security Exchange Act issue, which is that GEM is not a dealer. So if the arbitrator was actually aware of this circumstance of the Exchange Act, they would have had to have taken this under consideration and would not have been able to weigh the decision that was put out there in terms of the interim award. There is nothing in the record that demonstrates that the arbitrator made any such finding. So again, that just drives home the point that the arbitrator was not aware and did not review the Security Exchange Act concern about GEM and Mr. Brown not being a registered dealer. Section 3. Again, we're still talking about the estoppel. Plaintiffs did not have a full and fair opportunity to litigate the 15A issue in the arbitration, nor was resolution of that issue necessary to support the liability award in the arbitration. Courts in the Second Circuit generally consider 4 factors in determining whether a party had a full and fair opportunity to litigate an issue for the purposes of applying collateral estoppel: the nature of the forum and the importance of the claim in prior litigation, the incentive and initiative to litigate and the actual extent of the litigation, the competence and expertise of counsel, the availability of new evidence, the differences in the applicable law, and the foreseeability of future litigation. At least 2 of those factors weigh in favor of the plaintiffs, as the Exchange Act's claims asserted in the securities action do not address the SPA, Security Purchase Agreement, and the RRA, the Registration Rights Agreement, related claims in the arbitration, nor were they litigated to any extent in the arbitration proceedings below. Courts have also adopted the restatement of the judgment full and fair factors, which disfavor giving preclusive effect to the prior proceedings when treating the issue as conclusively determined would be incompatible with the applicable scheme of administering the remedies in the actions involved. All right, a little bit more background. The Supreme Court has held that arbitral awards should not be given preclusive effect when, number 1, Congress intended the statute at issue to be judicially enforceable, and number 2, arbitration could not provide an adequate substitute for judicial proceedings in adjudicating claims under that statute. Let me give an example or case study. Indeed, the Exchange Act vests exclusive jurisdiction in the federal courts over suits brought under its auspices. Finally, the proponent of collateral estoppel has the burden to make a showing and must clearly establish that an issue was necessarily decided. Again, they give a case study. An issue that is necessarily decided must have been both actually decided and necessary to support a valid and final judgment of merits. Here, plaintiffs' claims and/or defenses under the Exchange Act were never raised or pursued in the arbitration. So again, they're not clearly establishing the issue that needs to be decided, which would be the Securities Act agreement and the issues of them not being a registered dealer. As such, resolution of plaintiffs' defenses and claims under the Exchange Act could not possibly have been necessary to support the arbitrator's findings on liability. Section B. This is a separate claim. This court should stay GEM's application and any damages determination by the arbitrator pending resolution of the securities action. As discussed in the previous memo, if the warrant was indeed made in violation of Section 15A of the Exchange Act, it shall be void and subject to rescission. Such a finding would in turn render the interim award moot, as the $24,114,921 that MAI, Mullen Automotive Inc. was ordered to deposit into escrow was based on the minimum value of the warrant sought by GEM for breaches of the SPA and RRA. If the warrant is in fact void, then the amount would necessarily be reduced to 0. The issues presented in the securities action must therefore be resolved before the court can fully adjudicate GEM's application. Likewise, any pending arbitration proceedings pertaining to final damages must also be stayed in the interest of judicial economy and efficiency. So again, what Mullen's attorneys are saying, pump the brakes, stay this interim award. The Securities Act concern that Mullen's attorneys are bringing up is so important. This warrant section that was not mentioned in the arbitration is so important. It can zero out what these warrants would be worth if in fact they are illegal to be issued because they're not registered dealers. Then there's no award for the SPA and the RRA because the warrants are 0. And then before any kind of final award could be provided, basically if just to cover the basis that they continue with the interim award and then want to kind of round out and finish arbitration, it should not be done until this concern over the warrant and the Securities Act is finished. So the power to stay proceedings is incidental to the power inherent in every court to control the disposition of the causes on its docket with economy of time and effort for itself, for counsel, and for litigants. So that was pretty important, just to kind of state that is support for Mullen's attorney's claims that they should stay the interim award and basically finish out this Security Exchange Act concern in terms of the warrant contract. Want to go ahead and get into the next section. It starts with courts, and we're going to go ahead and get to the next slide so we can read the rest. All right, folks, thanks for sticking around. We are almost done, just a couple slides left. Picking up where we left off, courts typically consider 5 factors in deciding whether to grant a stay. So this is actually really important. This is actually helping confirm what the judge should do in terms of stay versus letting the arbitrator and the arbitration and this interim award continue on. So the private interests of the plaintiffs in proceeding expeditiously with the civil litigation as balanced against the prejudice to plaintiffs if delayed. So basically, if they kind of continue on, they don't stay, how does that weigh against how is that prejudice to if they go ahead and delay it? So obviously it's going to hurt the plaintiff if they don't delay it, if they don't stay it. So it is in the plaintiff's best interest for it to get stayed. The second section is the private interest of and burden on the defendants. So again, the defendants haven't paid Mullen any form of money at all. So they're not in any kind of like hurting financial type situation. Number 3, the interest of the courts. Again, if we're talking about how this warrant document and the Security Exchange Act will basically, if judged and ruled in favor of Mullen and their attorneys, it will nullify this SPA and RRA, then you're wasting the court's time if you continue on and proceed through arbitration. Number 4, the interests of persons not parties to the civil litigation. And number 5, the public interests. Courts in this district have routinely stayed an action pending the resolution of an independent proceeding, whereas here, the resolution or outcome of that proceeding bears upon the action. And they give an example of that. A staying case where resolution of a related class action would impact the plaintiff's claims in the case and defendant's contractual right to demand arbitration of the claims. So in that case, they basically talk about the 2 situations that I kind of slowed down and went through, which would be number 1 and number 2. The aforementioned factors indisputably favor staying GEM's application and any damages determination by the arbitrator pending resolution of the securities action, as Mullen Automotive Inc. would suffer irreparable harm in the absence of a stay, as explained in the previous memo, if MAI is forced to preserve $24 million in escrow. So again, they're showing how this would actually hurt the plaintiff, which is part of Section 1, and they actually give a little bit better explanation. I don't know if that's their financials that they're talking about, but they have to be able to show the judge how not granting a stay would be prejudice to the plaintiffs. And then a stay, however, would serve the interest of this court by promoting judicial economy and efficiency. Again, this was the Section 3 that I kind of touched on a little bit further, and avoiding potentially inconsistent adjudications. There's also nothing on the face of the interim award or GEM's application for the matter to suggest that the 4th and 5th factors articulated above weigh against a stay. As such, GEM's application and any pending arbitration proceedings to address the damages should be stayed pending the resolution of the securities action. So that's a final statement after all of the pertinent information was supplied. All right, last 2 slides. Section 3, Claim 3, there is no authority that stands for the proposition that a federal court possesses the authority to order the type of relief entered by the arbitrator in the interim award, Although the court may confirm, deny confirmation, or vacate the interim award under the procedures set forth in the FAA and New York Convention, there is simply no authority to suggest that a federal court possesses the power to provide the sort of relief entered by the arbitrator in the interim award and other MAI to transfer money directly into an escrow account. To be sure, federal district courts possesses the authority to issue provisional measures, including measures in the aid of arbitration. Under Rule 64 of the Federal Courts of Civil Procedure, for instance, a court may impose every remedy that under the law of the state where the court is located provides for seizing a person or property to secure satisfaction of the potential judgment, including arrest, attachment, garnishment, replevin, whatever that means, sequestrian, and other corresponding or equivalent remedies. Again, go ahead and look up some of those terms if you're not aware of them. New York law, in turn, provides that the court may entertain an application for an order of attachment or for a preliminary injunction in connection with an arbitration that is pending or that is to be commenced inside or outside New York, whether or not it is subject to the New York Convention, but only upon the ground that the award to which the applicant may be entitled may be rendered ineffectual without such provisional relief. Under New York law, a writ of attachment is the appropriate remedy for securing a judgment with property that is not subject of the action. And they give a case study. However, the remedy differs in material ways from the AAA Rule R37 and does not provide the court with the authority to order MAI to place funds directly in escrow. So basically, the court does not have the authority to do so. As an initial matter, whether an order of attachment is requested or on notice or ex parte, it must be sought by motion or application for that specific form of relief before a court can order such remedy. Even if GEM had moved for an order of attachment, and it hasn't, the court would still lack the authority to order MAI to transfer money into escrow. Courts have generally only entered orders of attachment in aid of arbitration where the evidence shows that the party has begun to dissipate, move, or otherwise encumber assets, even in circumstances where a defendant finds itself in a precarious financial condition. Let's go ahead into the next section there, as the attorneys are going to show that Mullen is not in this situation. Attachment in aid of arbitration, where the respondent was no longer actively functioning, there was some indication that the respondent had engaged in liquidating and transferring assets, and there was a high probability that the respondent would be unable to meet any debts determined by the arbitrator to be owed to the petitioner. They give the case study for that specific issue. Granting attachment where the evidence demonstrated that the individual respondent had stripped the corporate respondents of its assets, historically failed to pay its creditors, and stated to others that he intends to remove his assets from New York and does not intend to satisfy the award. So again, in this specific case, that is what happened. But according to Mullen's attorneys, there have been no such findings here. Moving on to the next paragraph. In addition, under New York law, a party seeking attachment, including one in aid of arbitration, must post a bond. Further, the property that is subject to the writ must be located in New York. In addition, any order of attachment is directed to the sheriff of the county where the property is located, and the property remains within the actual or constructive possessions of the sheriff. And they talk a little bit about how that specific law or that ordinance is laid out. None of these aforementioned requirements are found in the AAA Rule R37. In short, a federal court does not have the authority to enter an order akin to the interim award. So there's a whole lot of background, and just to help strengthen that last statement, which is that a federal court does not have the authority to enter an order akin to the interim award. And then finally, the conclusion. For the foregoing reasons, plaintiffs respectfully request that GEM's application to confirm the interim award and any damages determinations in the arbitration by stayed pending this court's resolution of the securities action. Additionally, plaintiffs respectfully request that the court refuse to enforce the interim award at this time. So they want to get it stayed, and they want the court to actually place the judgment to say that it cannot be enforced. So that would actually give them some backing to go back to the arbitrator and say, we took this to court, the judge has agreed that this interim award should not be enforced. And again, I wanted to give credit to the attorneys that wrote this memorandum. All right, and that wraps it up, folks. I just wanted to point out that I am not a legal expert. This is just my opinion and my interpretation of this legal document, this memorandum. Again, I am just a shareholder of Mullen. I do not work for Mullen. I do not work for any of these law firms. If you did like this video, please consider liking, subscribing to the channel. Leave me a comment below with any information that you'd like to hear more about, whether it be this specific case or it be some additional content that you'd be interested in. I'd love to hear from you. And with that said, I hope you have a great rest of the day, and I'll see you on the next one.